A pregnant woman, a deadly DWI crash, a courtroom that nearly explodes. What you're about to see isn't just emotional, it's outrageous.
Morning, Judge.
Hi.
I just want one thing I'll say. I have my client here on video. He can identify himself if necessary. I'm gonna just put my camera on. So.
This is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow.
This is,
Wow.
I don't.
Mr. Feldman, that's some good work, man.
I'm an
Great job.
immigration attorney, Judge. So I'm a salaried employee.
Yeah.
Really great job.
Well, I just mean if I wasn't a salaried employee, maybe it wouldn't be worth my time. I think that's an issue.
But representation is representation, doesn't matter, you know? Really, at the end of the day, everyone is. Shh.
I don't believe that. I mean, I spoke to the ICE supervisor and even he said, I.
Well, hold on. We need to go on the record. Sorry, Miss Saba, give me a second. Are you ready, Ramon? Okay.
Order in the court, going on the record.
So, Mr. Feldman, what's the last name again?
We're on the record.
An unopened beer can harmless or a chilling sign of what could have been. In court, optics matter almost as much as facts.
Have a seat, please.
Thank you. What's his last name again?
This is Cesar Moises Gabriel Perez. I think he's listed as Moises Perez on the.
Moises Gabriel Perez, Judge. I have a cause number.
Yeah, okay, let me have that,
Okay, it's
please.
529290.
Okay, all right, sorry, let's go on the record. All right. We are on the record. It is cause number 252-9290. Today is December 10th, 2024. It's approximately 9:44 in the morning. Parties, I'd like you to announce yourselves for purposes of the record, please. Beginning with state.
ADA Rojette Saba and ADA Kelsey Siegler here for the state.
And this is Noah Feldman on behalf of the defendant Cesar Moises Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well,
Wait just 7 days in jail. For a death, even the judge can't stay silent. And neither will the public.
before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit. I get.
If I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose. So what I just offer this to show that.
Is this his, or is this just a generic?
Generic.
Okay.
This changes everything. The defense attorney isn't just arguing the law, he's walked the crash scenes himself.
Exhibit 4 is going to be just proof that he's in ICE custody. It's a print off the ICE.
That's 4.
Exhibit 4.
Okay.
Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
Okay.
To withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standard ICE form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer, and it looks like I can see the defendant there, and it looks like he can look at us as well, but there's no translator, so does he understand what's going on?
That is correct, Judge. I do not believe he understands what is going on.
So now state, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket earlier this morning. I'm gonna need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day just.
This changes everything. The defense attorney isn't just arguing the law, he's walked the crash scenes himself.
If you don't want to roll it to tomorrow, just like an hour or so I can read through it.
Sure, of course.
And we did speak, or
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson. I relayed defense's requests for an order of supervision, and the officer said, he declined the request. He said that there would be no way that they would release defendant given that he is a flight risk and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before. He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. He also did say that the officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open. He's going to get deported, right?
That is my understanding.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge, if I may.
Okay.
Look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail.
She's pregnant. The crash is real. The evidence, murky. This is where justice collides with uncertainty.
Shall not be required. Section 19, which says that no citizen of this state, I don't think they mean U.S. citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, which is in Exhibit 2, which back after the ICE hold, the state requests a $1,000 bond for the defendant. Defendant posted the bond and without any volition on his own gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition interlock. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defective in the bond. If the bond is excessive, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. We could set him at $1 million bond. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different bond. Now, as I said, the only bond that this court could set that would guarantee my client comes to court would be a bond that is impossible for him to post, right? Because any postable bond, he would have no control in getting to court. Now, ICE, if I may, Judge, I understand what Ms. Saba relayed that the ICE officer said, but I can tell you that 8 CFR section 241.5 allows ICE to release anyone on an order of supervision if they're subject to a final order of removal. If you look at Exhibit 1, the ICE detainer, it says that if you need this subject to remain in the United States for law enforcement purposes, you can call this number at 936-520-588, oh, sorry, that's the wrong number, 802-872-6020. And ICE can consider whether the law enforcement purposes are serious enough to keep the person in the country. Now, I think it would be punitive to take away $1,000 from somebody who posted a bond that this court affirmed that the state requested and say, I'm taking away your $1,000 because of actions completely out of your control, actions that are being taken by a third party.
So if I bench warrant him back here, then nothing will happen to that then, right?
A bench warrant is a revocation of bond. Because if you bench warrant him, basically you're asking the sheriff to go get him, or you're asking ICE to bring him. ICE has already told Ms. Saba, we're not bringing him. The sheriff, if they go recover him.
No, they haven't said they said they were going to think about it, that they were going to look at it. They didn't say that they weren't going to.
Well, then let me clarify, Judge. If you want to bench warrant and be clear in that bench warrant that this is not a revocation of bond, I have no objection to that bench warrant. It's my opinion.
You had an objection last time to the bench warrant.
I have thought about it some more, Judge. If you bench warrant him, but there's no revocation of bond, I have no objection.
Well, then we're all happy. Are you happy with that?
Yes, Judge, I'm
Great.
fully deferring to you.
Let's do it.
Then let me say one more thing, Judge. I would request that on that bench warrant, it be clear this is not a revocation of bond. And let me tell you why.
Go ahead.
Because if you issue a bench warrant and there's no revocation of bond, the sheriff's office is not going to recover the body, because upon recovery of the body, they're going to have to release the body. And ICE could always, while he's in ICE custody, bring him, respect the court's bench warrant and bring him to the courthouse. I mean, I think
30 days in jail, 18 months probation, 1 life gone, 1 child unborn. What would you have ruled?
he'd be in civil detention the whole time. I don't think they can put him back there.
Sure
But
they can. They can.
I don't think they can make
Every time we
someone
bench warrant them, they go right back over there.
because they're in county custody by that point. But what I'm saying is ICE can keep him in their custody, which is civil administrative detention, and bring him to court if they so choose. Now,
Try.
they
We'll
can
try.
They can
You know?
try to do that, but I would just please ask this court, because I've seen it on numerous
I won't revoke it now, but let me ask you this.
Yes,
You know, I'm supposed to be fair.
Yes, Judge.
I can't show favoritism, right?
Of course, Judge.
If I were to essentially, if he gets deported and I never revoke his bond, where have you ever heard that happening before? Doesn't that show favoritism toward you?
How would that show favoritism?
Because I'm doing something and I'm allowing your client to remain on bond for eternity when I've never done that with anyone else. Essentially, he's on bond for DWI. He doesn't have to comply with any conditions, no matter where he is, whether he's in Abu Dhabi, whether he's in Africa, whether he's in Mexico, whether he's in Guadalajara. He's supposed to not consume alcohol. He's supposed to be monitored. He's supposed to have an interlock. And thereby, I'm saying, okay, here, look, you don't have to do any of these conditions. Everybody else does, but not you, Mr. Moises Perez.
disagree.
You are so...
I disagree, Judge, and here's why. The state of Texas works very closely with the Department of Homeland Security. The state of Texas, if they want to continue him on bond, which is their choice, because they want to continue the prosecution, they don't want to dismiss and refile, they can always put in a request that he be paroled back into the country for the prosecution, subject to the bond conditions. If you don't think that my client wants to remain in the country and follow your conditions, you are incorrect. We requested release from ICE. We requested that he be able to follow the court's conditions and abide by every single thing you put in that order.
You're apples and oranges. No, the point is that he's allowed to remain free on a DWI everyone else in our court has to follow a certain set of conditions, yet he's not gonna have to follow those?
He should have to follow it.
And Judge,
There's
just,
no supervision.
If there's proof
How
of
can I
him,
drug test him?
Judge.
How does he do the
then what's
analog?
The solution is either we're.
No. I'm gonna bench warrant him, but what I'm trying to get you to understand is that it's not fair. I have to be fair to the state, and I have to be fair to you. And I can't show favoritism. And I think that if I were to let him pass indefinitely without revoking the bond, if I were to, we're gonna bench warrant now this is theory, right? As a practical matter, I'm going to bench warrant him here for you. But in theory, right, wouldn't it show favoritism? I think it does. Because I'm allowing you and your client to do something that I don't allow anyone else to do.
But wouldn't it be the opposite if you were to take $1,000 from him that he lawfully posted at the request of the state and this court at no fault of his own? I also think that's unprecedented.
I get it, but he's in this country. You know, the right way to do things is you ask for permission, you come here.
Judge, that's completely irrelevant.
Well, no, it's not. You must follow the law, period.
But
And when you don't, there are consequences.
Judge, he was given the $1,000 bond at the state's request
Again,
after we knew he had a final order.
I just wanted you to see it from my perspective. That's it,
Judge.
right? I'm going to bench warrant him for you. I'm not going to revoke the bond. We'll try to get him here for you. If for some reason at that point they don't, we'll cross that bridge when we get there. But we'll try to bench warrant. Did you want to add anything?
yes, Judge, the officer Hudson did advise me that if you issue a bench warrant, if you want to send me a copy of that, I can email it to him directly, and as well as through whatever routes the court does it as well. But I can email it to him directly this morning if you do that.
That's incredibly expeditious, because I tell you what, it doesn't happen. You know what I mean? And literally when we issue a bench warrant, it takes a while to get to the appropriate person. It takes forever for them to think. It takes 3 months to bench warrant.
Judge,
So this is really expeditious.
I provided all the information, contact information for the ICE officers.
Judge,
Great.
actually,
So that helps, Mr. Feldman, you know?
Judge, just to clarify, the officer that defense tried getting me in touch with was not in charge of this case. Upon sending a message to that officer, he connected me to the supervising officer for this case.
Good job to both of you guys. You both did good. The idea,
is to be CC'd on all communications.
sure, of course.
Yes,
Everything's transparent here. No one hides anything. And I mean, I don't do the bench warrant. Usually Victoria does it, so I don't know the protocol to it. But
there's
that,
notification.
so whenever I guess when you send it via email, just if you don't mind CCing him.
Yes, sir,
Yes.
we always CC. Yes,
So,
sir.
Of course,
yeah.
Judge.
You're happy with that?
Yes, Judge, as long as there's no
Is happy
revocation.
too?
Yes, Judge.
Wonderful.
Thank you,
Thank you,
sir.
Judge.
Makes it for such a great,
Thank you. I appreciate it, Judge.
off the record.
Thank you, Judge.
Good job. Way to be tenacious.
We didn't.